post.
What we're going to go over a little bit today is just the changes for landlord tenancy court due to the pandemic and all the changes that are continuously being made. I'm going to start off by just explaining a little bit of what restrictions were put into place at the start of the pandemic and how that's affecting the complaints currently. You have to keep in mind that changes are being made at all times. This is brand new to myself, the court, to the judge. I've been doing a few different webinars, CLEs, to figure out exactly what all these changes are. And I've discovered that the changes are constant. Nothing is really staying the same. I think that the courts are really finding out what works best for them. And then they are tweaking everything a little bit to make sure that things can run smoothly. So what I'm going to do is I'll explain a little bit, like I mentioned, about the changes that were put into place and how we came to where we are today. I will be happy to answer any questions at the end. I will have to keep it more general just because any specific questions could potentially constitute forming an attorney-client privilege. So in the interest of just avoiding that, I can answer any general questions, and if you have any more specific questions, you can definitely reach out to me directly, and I'd be more than happy to go over that with you. So first off, Jersey City is one of the few cities that actually had a rent freeze put in place from March until August. And in that time, if the properties were rent controlled or 1 to 4 family, non-owner occupied, then you could not charge the rent. You had to hold off until August to request it. And in that time, you were not allowed to request late fees. Okay, so owner occupied 1 to 4 family, non-owner occupied 1 to 4 family or properties with rent control, you could not charge rent, you could not request the rent until August. Okay, and in that time, you could not charge late fees. Now moving on, if tenants requested to have their security deposit applied towards their back rent, you have to do that. However, you only have to if the tenant writes to you and requests it either in a letter, a text message. It must be in writing. Okay, any verbal request, you do not need to abide by it. You do not need to apply their security towards the rent. If they only ask you, say if they caught you on the street before they went into their apartment, you don't have to do it. You can tell them, send me a letter, and I'd be more than happy to. So once you get that letter, you do have to apply their security towards their back rent. Now, after they do that, and if they do that, you cannot request that they replenish that security deposit to make it full again. Okay, but the tenants do need to replenish that security either within 6 months after the state of emergency ends, which currently it's set to end on September 26th, unless it's extended, which I foresee it being extended again, or until they renew their lease, whichever is later. Okay, so in short, if they use their security deposit towards their rent, if they request that in writing, you have to do it. You cannot ask them to replenish it until either 6 months after the state of emergency ends or they sign their new lease, whichever is later. If a landlord has a property that has either a Fannie Mae or a Freddie Mac mortgage, and if they are unsure, I always tell them call their banks, ask them what type it is. The banks are more than happy to advise them what kind of mortgage they have. Then they were not allowed to file any complaints with the court until July 25th. Okay, that was pursuant to the newly passed CARES Act. I mean, the CARES Act is about 300 pages. It's very long. So you don't have to skim through it all, but the CARES Act did mention that if you have a Fannie Mae or Freddie Mac mortgage, you were forbidden from filing a complaint until July 25th. Now, once the complaint is sent to the court, the CARES Act also requires that the landlord with a Fannie Mae or Freddie Mac mortgage to send the tenant also a 30-day notice, letting them know that I have a mortgage. Because of me having this mortgage, I could not file a complaint against you. Due to the CARES Act, you owe whatever months it are owed. You can include in that letter whether or not security was applied towards any of the months that were owed. And this is a 30-day notice to vacate. If you do not vacate, then I will be filing a complaint. Now, right now, we have been filing complaints. My office has been filing complaints. I don't foresee us getting to court until sometime next year. Okay, it's very, very far out. I mean, I filed complaints back in June and I still don't have court dates. So because of the delays in getting to court, I am sending that 30-day notice simultaneously with the complaint. Okay, because I don't want to wait another 30 days when I know we're not going to get to court within 30 days. So I'm sending them both at the same time. Landlords were also forbidden from requesting rent payments from any tenants who owed rent if the tenants received any kind of federal aid, such as Section 8, anything from Hudson County, any of those organizations. Landlords could not request the rent that was owed from the tenants until July 25th. Courts right now are also requiring that landlords include the tenant's email address. That way the courts have another way to reach out to the tenants to try to schedule the court dates and the mediations. If you don't know what their email address is, that's fine. Not all tenants have provided those to the landlords in the past. Not all tenants are willing to provide them now. So if you don't have it, I've just been putting not applicable. It's the most you can do. Now, when the courts are getting the complaints, what they are doing is they are trying to reach out first to the tenants. So they are posting the summonses onto the tenants' doors, and they are requesting that the tenants reach out to the court in order to schedule a mediation, either via Zoom, phone call, whatever avenue the tenant feels comfortable, and whatever resources that the tenant has. Not all tenants have a laptop that has a webcam. Not all tenants have a working cell phone. So the courts are allowing the tenants to advise what way they would prefer to try to mediate. Now, the courts are still unsure. If they don't hear from the tenants, they can't schedule a mediation. They're giving the tenants about, I believe the constable, last constable I spoke to mentioned that they're going to try to allow the tenants 10 days to reach out to the court. And if the court does not hear from the tenant within 10 days, then the court is going to try to reach out to the tenant directly. And at that point, they're going to try to schedule a mediation. I haven't received any mediation dates yet. I did a CLE, a continuing legal education course on last Wednesday, which included 2 attorneys and also Judge Lyons, who is the presiding judge over the landlord tenant court in Hudson County. And none of those attorneys have yet to receive any mediation dates. Now, it's important to note that when we do receive those mediation dates, neither the landlord nor the tenant have to agree to any kind of agreement. You don't have to agree to do a pay and stay, a pay and go. You can't force anyone to make an agreement. Okay, the judges and the courts are really just trying to schedule these mediations to limit the amount of cases that do have to go to trial. So they are trying to see whether or not we can work anything out, but you can't force either side to do anything. Now, if both sides are willing to come to an agreement, for example, if they're willing to do a pay and go, which would state that they are willing to either pay a certain amount or not pay a certain amount, but be out by a certain date, or if they're willing to do a pay and stay where they come up with a payment plan until they are current with their rent, then typically at court what you would do is you would have a form. The landlord would sign it, tenant would sign it, the attorneys for either side would sign it, and we would submit the pay and stay to the court, and the pay and go we would submit to the court, but we would also have to go on record. Now, when I did the CLE on Wednesday, I asked the judge, how exactly are we going to go about getting everything signed? How are we going to go about getting the pay and go on the record if we are not at court and with the delays in getting everyone available to go in front of the judge? They're still not sure. They're going to try to waive the requirement to have original signatures so that we can just have electronic signatures, which is another reason why it's very important to get the tenant's email addresses if you are able to. And the judge mentioned that she would like to put everything on the record. So like I mentioned, usually only the pay and go is put on the record, but it seems like their intention is to put everything on the record, just to have everything as proof that all parties are agreeing. And they really just want to do as much as they can to limit the amount of cases that have to go to trial, because like I said, I really don't foresee the court opening and allowing people to actually go to the courthouse in person until sometime next year. Who knows when that'll be. Let me see what other specifics were enacted. Now, no evictions are allowed for up to 2 months after the state of emergency is lifted. As I mentioned before, the state of emergency is currently set to lift on September 26th. Most likely it'll get extended, but whenever it does lift, we still cannot actually lock anyone out for 60 days after that date. Okay, so it's going to be a while. Commercial matters. Typically, those are different from residential, of course, because you have a storefront rather than where someone is living. Now, the commercial matters typically would have been filed before. When I was filing cases back in June, what I was doing was when I was sending in the letters, in big letters, I was writing, "This is a commercial matter" on the very top, hoping that they would move mine to the very top of the file and they would start to schedule those first. I haven't heard anything about those. That court that I was in on Wednesday, the judge mentioned that they are going to try to start scheduling those commercial matters. But what they'll have to do is reach out to both the landlord and the commercial tenant to get consent from both sides. And another attorney actually asked the judge, what happens if you don't get the consent from one of the sides, or if you can't reach out to one of the sides? The judge even herself said, the court is not sure. So they're learning as they go. You know, nothing is really set in stone. Things will be amended as we progress. I'm sure once they actually start to schedule the mediations, then they will start to figure out what is working best. Is it best if we're able to say, let's do a Zoom call and everyone go to the landlord's office, or go to your attorney's office if you are both represented, so everyone can be in one place? I don't know what they're going to do. And I'm sure a lot of people might not even feel comfortable doing that due to the pandemic. Maybe some people don't want to leave their house. Maybe some people don't feel comfortable going and, you know, going into busy areas, going into Jersey City, going into, you know, if they're somewhere else in Hudson County. So I don't know exactly how it's all going to play out. But the important thing to recognize is that this is completely new to everyone. It's new to the judge, to the court staff, all the attorneys. We're all scrambling to, you know, make a compiled list of what executive orders were passed, what the CARES Act states, what the courts are requiring, and how they're going to go about opening back up, what precautions they're going to take, what issues they'll be able to handle outside of court, what we can try to do instead of going to court. I know a lot of landlords are going to be very upset. I have some landlords who were owed rent back from March, and I was actually supposed to go to court, I believe was March 17th, and the courts closed on the 16th. So I still have a lot of tenants who might be out a full year's worth of rent by the time we get to court. So it's going to be very hard, and I think that the court understands that, and that's why they're trying to schedule the mediations right now. Because even if we come to an agreement during these mediations, like I said, we cannot lock anyone out until 60 days after the state of emergency ends. Okay, so that's really just a Band-Aid fix for a while to see what we can do, what we can get off our desks, what is able to be settled, and then everything else is just a waiting game. Okay, so I mean, I know I went over a lot. There's a lot of different nuances with everything. There's a lot of different executive orders and CARES Act statutes and everything. So I'm going to open it up to all of you to let me know if you have any specific questions in regards to anything I spoke about, or if you have any general questions in regards to filing complaints or landlords who are owed rents or anything of that sort.
So I had a question, Tara. So
Sure.
The first step is we have to wait to September 26th, even if they're late to even start the process, correct?
So I'm already, and most attorneys are already sending in our complaints. So you can send in your complaints. It's just that September 26th currently marks the end of the state of emergency. So 2 months out from September 26th is the first time you could actually evict someone. So I'm telling everyone, if you are owed even 1 month's rent, file the complaint, because you are most likely not going to get to court until sometime next year.
There's something online that we can have our landlords file that complaint, or how do they file that complaint?
They can decide if they would like to represent themselves pro se. They should be able to reach out to the court and possibly get a copy of the complaint to fill out on their own. It's important to note that if you are an LLC, you require an attorney. The courts will not hear your case if you are an LLC. But I believe the NJ Court's website has a blank form for the complaint in order to fill it out. Otherwise, if they don't feel comfortable, if they're not sure, you know, with all these nuances, with accepting security as back rent, the CARES Act certification that the judges and the court staff is now requiring, if they're unsure about different things that typically wouldn't be in place, then they should definitely reach out to an attorney, because the last thing they would want is to file a complaint now while having a mortgage on the property, not sending that 30-day notice that's required, getting to court, and the judge throwing it out because they did not follow each and every step that they were supposed to take.
So it's best if they just put it in an attorney's hands, even if they have to pay the money, it's best, because if they miss a step,
Right. I mean, typically it's a lot different right now than it is, you know, during the normal times. Normally, if you're an individual filing a complaint, you file your complaint, you have either your landlord registration if you're a 1 to 2 family, or a building registration, or your green card if you're 3 family and up, and you're pretty much good to go. But now with the pandemic, you need your complaint, either your building, landlord, or green card registration, depending on what type of property it is. You need potentially your CARES Act certification and your 30-day notice to the tenants, depending on if you have a mortgage with the property. So there's a few different things that have since been added that if you are unsure, you're better off going to an attorney, because like I said, we're not going to be getting to court until sometime most likely next year. And at that point, if it gets thrown out because you did not follow all the required steps, you're going to be kicking yourself, because if you have to refile at that point, you're not going to be heard until God knows when. Any other questions?
I have a question. And this is probably for the tenant. Since they're not paying rent due to COVID, and the landlord filed eviction, and so now they have this judgment on their file. So, you know, when we run the background check, we usually check for evictions or judgments. Now, let's say that period they do have an eviction or some sort of judgment because they were late with their rent. Would they still be held against, would that be held against them if it's in that time period of COVID?
Most likely it still will, because if you have that complaint filed against you, that is still something that could go on record. I mean, any court complaints are public record, so you can look them up, and it's nothing that can be hidden. It is definitely something that could also affect their credit score. I actually have a lot of landlords who don't look too much into depth before they decide on who is allowed to be a tenant, and I yell at them each time because I go to court and I'm like, where's your background search? What did you do? And they're like, I didn't do any of that. And I'm like, well, there's your problem. And then they find out down the line, I don't know if any of you have seen it, sometimes there's different organizations and they'll send you a little tiny postcard with the tenant's name saying that they have been kicked out in the past. And landlords get mad because they say, why did I get this now? And it's really just, I think that I don't know what organization does it. I don't know how they get the information, but they're able to see which tenants have multiple cases filed against them. And then they sometimes send that to the current landlord. And that's the first time that a lot of them will know that the tenant has been evicted multiple times in the past, because they don't do their background searches. But yes, I would say that if they are, if any cases are filed against them during this time, even though we're in the middle of a pandemic, it will still be public record. It will still be something that potential future landlords can see. And if there are any judgments against them at court, it is still something that can affect their credit negatively.
I was thinking, I'm sorry, I was thinking because you said early in Jersey City, the rent, something about the rent is free from March to August. Like they didn't have to pay their rent.
It's
I mean,
basically,
eventually they have to pay it, but I'm just saying.
right.
Like,
Right. So it was basically just from March 1st until or August 1st. They did not have to pay their rent. The landlord could not request it. The landlord could not charge late fees. But come August, all of that is owed. Think of it in terms of if you put your mortgage on deferment, it might be deferred for 3 months, but on that next, once it's no longer deferred, that entire amount is due at once. And if it is not paid all at once, the landlord is completely free to file their complaint.
Are you saying that a potential landlord has the right to go to the court to get information on a tenant prior to?
I wouldn't say go to the court. I'm just saying that if they do a background search, they are typically able to see any potential cases that were filed against them, no matter what court it might have been in.
Okay.
And I'm just saying that there have been times when I go to court with some of my landlords and they will bring with them a postcard that they have received from different organizations that keep track of what tenants have been have had multiple cases filed against them. And I don't know what organization it is. I don't even have a copy of one here with me where I would show you guys who it is or see if I can find the organization on it. But it's typically just a little notice from some organization that keeps track, sends it to the landlord, says, this tenant has been evicted before or has been in court before, and it just puts that landlord on notice. It really doesn't have any effect. If the landlord is smart and does their due diligence and they do their own background search, then they would find out whether or not that tenant has had any prior evictions or prior complaints filed against them at that time, rather than waiting until they get to court and waiting to see whether or not they receive a postcard.
Okay, I got it.
So there's a lot of people having hardships right now, so they may be inclined to stay with their friend or their relative that is not on a current lease. And that means there's more water and possibly electricity for the current landlord. What can we do with those who are violating a lease by having other people there longer than a 2-week period?
So anything like that, I'm telling any of my landlords what you have to do. You either have a lease or you have potentially an expired lease, or you just know who is living there and they are the ones who pay you your rent check, correct? So if you have additional people who are living there, then I advise them that we should send a notice to cease. Now, I would need to know potentially all the other tenants' names who are living there, anyone who's staying with them, but I can put in that notice, we send that both regular and certified mail, that their lease or their month-to-month lease only allows X or Y to remain at the property. However, they have these additional persons, any information that they can provide to me about, specifics of when did they move in? How long have they been there for? How many people are there? Did they bring pets with them? All of that I include in that notice to cease, and you have to give the tenant the option to correct that. Okay, so anytime you send a notice to cease, you are basically just putting the tenant on notice that they have violated their lease and that they must cure that default that they are in. Okay, if they do not cure that default, in this instance, having those additional persons vacating, then you have to send at least 2 to 3 more. Okay, that shows that they are habitually violating their lease, and it shows that they are not doing anything to make themselves current and to make themselves right within that lease. At that point, you can send them a 30-day notice to quit based off the fact that they have not abided by their lease. And if they do not vacate the premises within that 30 days, you can file a holdover complaint with the court. Okay, when you get to the court, I would have to, or any attorneys, any landlords would have to bring in a copy of all of the notices to cease. They would have to bring in proof of the certified mailing to show that it doesn't matter if the tenant signed for it or not. You just have to show that it was sent to the correct address. And at that point, you show the judge, I gave them multiple different occasions that they could have corrected what they were doing, and they failed to do so. Because they failed to do so, I sent this 30-day notice, which would also be sent both regular and certified mail, so you have that proof of mailing. Okay, and you would show all of that to the judge. The judge would ask the tenant anything that they might say. For the most part, you typically get an eviction against them. But like you said, right now with the pandemic, things might be different, and we won't know that until we get to court. Some people might file for hardship stays and the judges might grant them. If the judges do grant them, any hardship stay can be granted for up to 6 months. Now, no judges typically give the 6 months right off the bat. They will typically give 2 to 3 months of a hardship stay, and then they will reassess it after that time expires. However, in order to get a hardship stay, the tenants must pay any rent that is owed. So for example, if you get to court and the tenant owes $5,000 and the tenant requests a hardship stay because they lost their job, they're in the middle of finding a new place or anything of that sort, they must deposit that full $5,000 into the court or give it directly to the landlord. And at that point, the judge would decide whether or not to grant them the hardship stay. But if the tenant comes in and says, I need to stay for X reason, I need this hardship stay, but I do not have the money, the judge will not grant it. Okay,
So
that is
they
one of
have-
the requirements.
So if they have multiple things, so they smoking pot, we put a notice in. They having parties, we put a notice in. To show that they have a habitual violation of their lease, but we must
Right.
put those notices in each and every time.
Right, exactly. And each time, for instance, if they are smoking and it is a tenant who is complaining, for example, if you have a first floor tenant who is partying, if you have a first floor tenant who's smoking, and it's the second floor tenant who's complaining to the landlord about all of those instances, if you file the notice to cease, if you send the notices to cease, send the 30-day notice, and then you have to go to court because the tenant fails to leave, you would need to have that second floor tenant there as a witness, because they need to be there to state that, yes, I smelled smoke, I saw the partying, the music kept me awake until 4 a.m. You do need to have them there as a witness. Otherwise, any claims are hearsay.
Tara, you mentioned earlier about like Section 8 and government programs, like certain tenants may pay a portion. And landlords, they can't collect that portion as long as they get in, I guess, the portion that say tenants have to pay a portion. Would they still be obligated to collect that after the pandemic is over?
Yes, so the landlord is able to collect any rent that is owed to them by any tenant, by any Section 8, any program such as that. The only thing that was enacted pursuant to the CARES Act was that landlords were forbidden from requesting rent, from sending any notices or filing any complaints against any tenants who were receiving that federal aid from the time from March 1st through July 25th. So if you have a tenant who was Section 8 and they owed you rent, until July 26th, you could not request the rent. You could not file a complaint for the rent, but you were able to collect it if, for example, if it was out of Jersey City, or if the tenant was just providing you the rent, you could take it, because even though there was that rent freeze, if the tenant is willing to give you that money to make sure that they are current with that rent, you were able to collect it. The only thing with that rent freeze is you couldn't request it from the tenant, because technically Jersey City gave them those 3 months essentially of a forbearance on their rent.
So I'm just wondering, like, are the courts going to be flooded with landlords not getting rent? I mean, is it really bad out there?
Yeah, I mean, so to put it into perspective, I filed 2 complaints a couple weeks ago. I filed them pretty much back to back after you scan them with the court, because typically they would allow us to make copies and to mail it into the court. Right now, what the court is doing is they're requiring it all to be submitted electronically. So I submitted 2 back to back, and in the time it took me to scan and submit the other one, which might have been 3 minutes, there were about 40 other cases filed.
Wow.
Tatiana, you had a question?
Yes, I have a question. Would you please share with us how much actually it might cost to the landlord to get the eviction, and how much is it to file the complaint to the court with the attorney?
Sure. So my fees are $650 plus the court filing fee. I don't collect everything at once. What we do is when the tenant, or excuse me, when the landlord comes in to sign the complaint, I collect $375 at that time plus the filing fee, and at court, the balance of $275. Now, the filing fees are different for Hudson County based off of the city that it's being filed in. So for example, in Jersey City, the fee is $51 and $5 for each additional tenant. In Bayonne, it is $56 and $5 for each additional tenant. In North Bergen, it's $55 and $5 for each additional tenant. In Union City, $47 and $5 for each additional tenant. So really the filing costs per city and per town differ. So, I mean, there's not one standard filing fee for that. But yes, when you have an attorney, you just tack on the filing fee, which is, as I mentioned, any tenant plus additional tenants. Now you only have to charge for each tenant who's over the age of 18. So for example, if you're the landlord and you have 2 people living in the apartment who are a mom and a dad, and you have 2 children who are below the age of 18, and the house is in Jersey City, you're charging $51 plus $5, so you're charging for 2 tenants. You do not have to charge the filing fee for the 2 minors.
Okay.
Okay, I think, did I answer everything right there?
Yeah, I think so. Yeah.
Okay.
Tara?
Yes.
Hey there. I was wondering if you can tell me what my client, who's a landlord, should do in her situation right now. She has a 2-family in the Heights, and the tenant that's on the 12-month lease ended up working the system once COVID hit, and he got all these extra tenants through like homes.com and Craigslist to sublet different rooms. So the house is overoccupied now. If there's only supposed to be like 3 people in there, there's probably like 6 or 7. He hasn't paid rent, so he's making money. He's overcharging these people that can't get an apartment on their own because they don't have proof of employment. So he's taking advantage of them and overcharging them, and not paying rent to the landlord for some months now. He has left the property about a month ago, but the people that are in there, which are strangers to my landlord, she doesn't know who they are, they paid up till November already. And so the tenant said, okay, I left the place, but now you have to get these people out of your property. She did go through, the court was suing her, or she was getting sued by the city, I guess, because it was overpopulated and becoming a disturbance. But she went to court and told them what happened, so they stopped fining her every day. They were fining her like $1,000 a day. But she still gets noise complaints. It's just like becoming too crowded and dangerous, like a fire hazard. And so what can she do to take possession of her property? Because her real estate attorney, I think he's just like a real estate attorney, I don't think he's a tenant landlord attorney, just says you can't do anything because of the eviction moratorium.
So, okay, so first off, I just want to say I can't give specific advice in this webinar just because I don't want to form that attorney-client privilege. So if you want more information, you can definitely reach out to me. But just to clarify, you mentioned different rooms. He's subletting rooms within that one apartment, thus making it essentially a boarding house? Okay. So, I mean, I will just say generally, because like I mentioned, I can't talk too much specifically. Generally right now, you cannot do too much in regards to the landlord tenant because you're not going to get to court. You can definitely send notices to cease. You can definitely try to, I'm telling some landlords, just try to pay some of these people, get them the hell out, get your keys back, form an agreement that anything that they leave behind is going to be deemed abandoned and disposed of. Just get them gone instead of waiting around for months, if that's something that the landlord would be interested in. But I mean, yeah, right now your options are pretty slim because the courts really aren't doing too much. Now, if you have a specific attorney who just does landlord tenant, they could potentially order an emergency order to show cause to get it in front of the judge quicker. and in a way to try to, get the case heard quicker, to try to evict the tenants quicker. I will also just state that my office typically, in terms of landlord tenant, because we do a lot of real estate, workers' comp, personal injury, and with regards to landlord tenant, we mostly do leases, notices to cease, notices of rent increase, notices terminating leases, and just simple complaints for non-payment of rent and complaints for holdover. So a more complicated issue such as that, my office typically would not even handle. I would refer that out. But if you want to give my office a call after this, I can give you the phone number of another attorney who only does landlord tenant, and he might be able to better assist you and give you more information in regards to your situation, since I can't really go too much into specifics.
Okay, thanks.
You're welcome.
I just put Tara's information, Amadeo Miller, 1767 Kennedy Boulevard, here in Jersey City. Phone number is 201-433-8510. 201-433-9798 is the fax. Longtime family law office here in Jersey City, very well respected. So her father does real estate all day in his sleep too. And Tara, she does the landlord tenant. So if we can reach out to them, both real estate matters as well as landlord tenant, for what she just said she does do.
And I'll also just mention too, my email address it's my initials, TKM, the law firm name, Amadeo, AMADEO, Miller @gmail.com. And Karen, if you could put that in the chat as well. And then Tatiana, I think you had another question?
Yes. Would you please share with me these things? So if can the landlord actually right now during the pandemic increase the rental price? For the
Currently you can. In the past, like I mentioned, until July 25th, you were not able to raise the price if you had a mortgage on the property or if the tenant was receiving federal aid. But right now you are able to. To be honest, I do not know how successful that will be. I'm sure the tenants could potentially say that that's unconscionable no matter how much you raise it, because of the issues of so many people are losing their jobs. They don't have the typical job security that they typically have. So I do not know how successful they would be in making sure that it is enforced, but you can definitely send one out.
And for example, if the landlord would like to increase the rent, how many days before the increase in the rent he has to send a notice of increasing the rent?
Okay, so in order to send a notice of rent increase, you need to make sure that the current lease is expired. Okay, so that is the first step. You cannot have a current lease. Now, when you send it out, you need to give them 30 days, but that is 30 days within the rental period. So for example, if I sent one out today on September 22nd, that does not mean that the rent is raised starting October 22nd. Okay, you would have to send it out. They would have the full month of October. So starting essentially November 1st, the rent increase would take effect.
And for how much they can potentially increase the rent officially, legally?
So it depends on whether or not the property is it has rent control. If it has rent control, then the rent control board would essentially decide how much you are able to raise the rent, and you have to work them out with them. If it is only a 1 to 2 family property with no rent control, then it's entirely up to the landlord. I always tell people, do not do it more than $200, because anything more than that, the judges typically deem to be unconscionable. But that also depends on how much the tenant is currently paying. Now, if the tenant is currently paying $1,800 and you try to raise it $200, that just seems like chump change. However, if you have a tenant who's only paying $700 and you try to raise it $200, then that's a different issue. So you really have to take into effect the current rent that is being paid, as well as potentially the other comps in the area. How much are the other apartments being rented for, and go from there. But I would always say, do not do it more than $150, $200. And you can only send one rent increase notice per calendar year.
Okay. And what if the current tenants is not agree on that rent increase, can they somehow negotiate that?
So the notice of rent increase that my office would send has in there specifically that, so let's just say, for example, I sent that out today, okay? That would mean starting November 1st, like I mentioned, the new rent would take effect. Now that notice would state that if you do not agree to the new rental increase, you must vacate by November 1st. And if they do not vacate, then it is assumed that they are agreeing to the rent increase. Now, if you, let's say, for example, your rent was $1,200 and you raise it to $1,400, come November 1st, they only pay you that $1,200. I will tell the landlords typically not to accept the $1,200, and we would do a complaint for the balance that is owed. Or you can collect the $200, write them a receipt, because I want to make sure that the tenant doesn't try to come around and say, well, I gave you the $1,400, I gave you extra, I gave you Y. Not all tenants are the most reliable. So I would always tell people, do a receipt. If you take that $1,200, fine, but we would have to put in the complaint that the balance of $200 is still owed.
Can the landlord himself send a notice of a rent increase? And if it's just a physical, just a normal person, or if it's LLC, is it any difference for that notice?
Nope, no difference for that. The only difference usually between the LLC and an individual is just that an LLC requires an attorney at landlord tenancy court.
So the LLC landlord can actually send a notice of increase himself.
Correct. The only thing that I will say about that is I have a lot of landlords who try to do it on their own. And when the tenant does not abide by the rent increase, they bring it to me because they want me to do a complaint for them. And I take a look at the rent increase notice and it does not have the required language that is necessary. So typically I would say go to an attorney, make sure that you have all the correct information, all the correct statutory terms. You send it out regular and certified. You make sure you do it with the correct. So many people think 30 days means just 30 days from today. They don't realize that that means all of the next rental period. So if anyone has any questions, I would say get an attorney, because it's better to get an attorney, pay $75 and have it sent out now, instead of sending out a notice and then 30, 35 days from now, you come back and we have to send a new one.
Okay, and my last question, for example, if the tenant potentially agreed on increasing the rent, however, some of the parts of the apartment need some replacements, renovations, simple like, I don't know, like carpet is very dirty because they are staying for so long time and they are requesting just to change the carpet or clean the carpet, deep cleaning, whatever. So, is there any way for tenants request that to the landlord when they received that increase letter?
So you're saying that the tenants would potentially request that the landlords make the changes or potentially have that taken away from a little bit of their extra that is owed?
No, not taking extra that owed. Tenants agreed on price increase, rent increase.
Right.
However, they are asking the landlord to make some updates or renovations to the apartment. For example, the carpet is very old because they are staying at the apartment for a long time and it needs to be changed or deep cleaning. Which is the right way for tenants to request those updates or renovations?
Okay, so first I would say to check the lease, because sometimes leases will state in there that certain cosmetic things such as cleaning a carpet would be the tenant's responsibility. So I would tell them first to check their lease and see if there's anything specific on there in regards to that. If there's nothing specific, typically it's not the landlord's responsibility to clean to clean the carpet. It's something that it's most likely dirty because the tenant has been living there for so long and it's a cheap fix that they can do. So I would tell the tenants just to do that on their own. Don't make a big deal about it. But if there are issues such as the heat not working, the air conditioning not working, major issues that affect the habitability of the apartment, then you have to reach out to the landlord in writing. That way you have proof that you did request it to be fixed. And it is then the landlord's responsibility to go in and make any of those repairs. But anything cosmetic, I would say check your lease. Some leases are specific as to whose responsibility that is. And anything small, I mean, any changes you want to make, typically it's up to the tenant to do.
I'm sorry, my last question. One time I saw in a lease that the landlord requested to vacate the property at the end of the lease with the carpet at the same condition as it was, but it's completely impossible because it's just normal tear and wear. And
Right.
is it legal to request that from the tenants?
I mean, I don't really know exactly what the landlord would have meant by that. I mean, potentially just meaning no big stains, no rips, no tears, such as that. But yes, like you said, when tenants move out, they do move out with items having the reasonable wear and tear, and landlords cannot go after them. For example, if the paint is chipping because the tenants lived there for so long, that's just reasonable wear and tear. The landlord's going to repaint it anyway before they have the next tenant move in, and they really can't go after the tenant or deduct from their security to have it repainted. So, I mean, they can probably request, don't spill wine. If you have any cats or dogs, make sure that there's no obvious stains. But yes, I would say for the most part, all of that is reasonable wear and tear, and any other request about that would be ridiculous.
Okay, thank you so much. Appreciate your help. And I would say, I want to say that you sound so professional and you explain so nice and understandable, and we appreciate that.
Thank you so much. Happy to help. Are there any other questions?
Do you see it hard to sell properties right now? Like, let's say if someone owns a 2-family and they're just done with dealing with this mess with tenants, and the lease expired for both the units, can they just sell it and have the owner occupant move in? Or does the eviction moratorium protect people? Like, can the tenants stay there for the end of the year because they don't want to spread COVID? You know what I mean? Like, have you seen situations like this happen where sellers aren't able to vacate their properties?
Yeah, we've also seen a lot of tenants not feeling comfortable having people walk through for their walkthroughs, people walk through to do their inspections, people walking through just before they put in their offer. So it's definitely affecting a lot. It's hard to get open houses. But if any purchasers want to have that property or one of the units vacant so that they can move in, it's still the same process of sending a 60-day notice, as long as that tenant has either no lease or an oral lease, an expired lease, whatever. You have to make sure they do not have a current one. But if they do not have a current one, you can still send a 60-day notice to quit, stating that the property is under contract of sale and the new owner requires personal occupancy of it. You give them that date and the notice of when they're supposed to vacate. If they do not vacate, then you have to file a holdover complaint. And really that's just going to be the same process of waiting around until you can either get a mediator or you can get a court date, and waiting until the state of emergency is lifted, because like I said, you cannot evict them until 60 days after that.
So that would be the current owner to do all that, not the new buyer.
Right. And if you close on the property before that tenant vacates, then for the most part, that case can be deemed moot, because if I were the owner of the property and I had to send those notices, and then Kara and I sold that house to you, my notice is that I no longer have standing. I am no longer the owner of that property. So you would then have to send them a 60-day notice stating that you plan on moving in. So the owner, if they're sending a 60-day notice for the buyer, they need to make sure that that tenant is out prior to closing, unless the buyer just decides, you know what, I don't want to wait around for this. Let's just close it now and I'll send a new notice down the line.
Because you might be having your interest rate at a 2.5 versus waiting another month and then going up to 3.5. Just take it now and work the deal out yourself.
Right. And really, I mean, that's another thing that we're seeing is the rates for mortgages, they're fluctuating. You know, one day it's 5%, one day it's 2.75. You never really know. And, you know, some people who otherwise would have qualified no longer qualify, either because they lost their job or they're not sure about what their job is going to do. Some lenders have actually raised the minimum credit score, in which case some people who are looking to buy the house who would have qualified before no longer qualify with the higher credit score requirement. And a lot of people are having their mortgages withdrawn, and a lot of people are not selling their houses right now because they don't feel comfortable having strangers come and do walkthroughs through the house, to have inspectors coming to the house. So we're seeing definitely less houses on the market and less buyers. I mean, if you're a cash investor, if you know that you have that job security, now is the time to buy, because, you know, the mortgage rates are definitely lower. If you know that you're going to qualify for a mortgage if you need one, then, you know, you may as well go for it, get that lower interest rate. But there's definitely less to choose from right now. I mean, our intake right now is down about 85% from what it usually is.
That means y'all slow over there.
Yeah, I mean, we're still getting some new contracts, but in the past it was, you know, 10, 15 new ones a day. Now you get 4 or 5 new ones a week.
Wow, that's not doing a lot for our industry.
Exactly, yeah. And I mean, honestly, I think that this is going to mostly just be, you know, it's not going to be, this pandemic is spurred by a virus. It's nothing economic. I think it'll be more of a V-shaped recession rather than a U-shape. I think we'll have a quicker bounce back because of the fact that it's due to a virus and it's not due to too much of economics. I think that, you know, it'll be a little bit better to bounce back from, but that could still be a year out from now. No one knows. Any other questions?
If I have any other questions, we want to honor Tara's time and thank her for coming out and doing our Zoom with us. And you have her contact information. No questions? We thank you so much, Tara.
I wonder what I should tell my seller, because he has a 2-family, but they both have tenants in the units, and the bottom is on a month-to-month.
Okay.
But the top, they just signed a lease in March, right? But the top is the one that hasn't been paying rent. And the buyer, I think, is probably going to take the top. You know, if it's like an owner occupant, there's more space for them, because the bottom is a better tenant that pays rent on time. So, I mean, maybe
something like that, I would potentially even say, do the complaint for the tenant who's not paying on that second floor. You can still send a 60-day notice to evict the first floor tenant so that the buyer can move into the first floor. And then once the buyer has moved into the first floor, after the second, whether you have the second floor either could be evicted at court for non-payment of rent, and if they paid their full rent and they stay, once that lease expires, the owner who would then be living in the first floor can then send a 30 notice to the second floor. I mean, it would take, you have to be in for the long game, but it can be done to get them out.
I think, what if the seller says, you know, to the second floor, the problematic tenant, this is a different client than the earlier drama, by the way, totally different. What if they say, like, listen, you're late on rent, you still have 6 more months on a lease, should we just break the lease? You know, that way you don't have to owe me the back pay. And then do you recommend a cash for keys? Because there's no other way to, like, get these people out of your property, really. Because even if even downstairs, the girl, her lease is over. It's been over. Like, if she really wanted to, she could stay. You know, like.
Right. So, I mean, what I would say for that is, really for any of my landlords who are coming and saying the person still has time left on their lease, or this person owes these amounts of all these different months, we're not going to get to court until sometime next year. If the landlord has a good relationship with the tenant where they think that it's something that they can discuss, I am recommending that the landlords reach out to the tenants, see if they can come to an agreement whereby you say, if you move out on X date, then not only do you not owe me for the past months, and I won't go after you in small claims court or in civil court, depending on how much is owed, then I will just let you go free and clear. Sometimes even saying, give them their security, give them a couple extra thousand, get them out, but do not give the rent or do not give the cash until you have those keys in hand and until you sign an agreement that anything that's left behind in the apartment will be deemed abandoned and disposed of, because that makes it so that the landlords do not need to hold on to the item for 30 days. Typically, if a tenant moves out, you have to hold on to those items, whether it's stay in the apartment or you move it to a storage unit. So if you put that language in an agreement, then you can just dispose of it immediately. And some tenants are really open to that because they know that the rent's going to be due at some point. You know, they might be able to escape this a little bit. They might be able to outrun it a little bit longer, but the rent is piling up. It doesn't change the fact that this pandemic might be making it so that their rent is not currently due at the moment. It will be due. And I think that a lot of tenants are realizing that and realizing you can take them to small claims or civil court, and they don't want to have that against them. So a lot of them would be willing to not only move out if they know that you won't go after them, but also move out if you're giving them a couple grand to find a different place.
So we can use that language, or the landlords can use that language that I won't go after you in small claims and put an eviction if you
Yeah,
just
they
move out
can
now.
absolutely put in there, you currently owe me X, Y, and Z. The landlord will waive all rights to this money and will not pursue any legal action in regards to obtaining that money. And in response, the tenant will be moving out on X date, keys to be handed over simultaneously with the check handed over from the landlord. Any items left behind deemed abandoned and can be disposed of.
How much would a simple letter like that coming from an attorney office cost us or cost the landlord?
Typically 75.
It's worth the 75.
Yeah.
Guys, just get your clients to the attorneys, and Tara Miller is here to represent. I hope this was
And hey, it's worth it to. Does anyone else have any questions? I don't know if I've answered everyone's.
Well, you have her information, you have her email. Please reach out to her, and if it's something outside of what she couldn't answer on here, she'd be free to talk to you after the meeting on a one-on-one.
I have a statement.
Oh, sure.
I'd like to thank you, Tara, for your time. That was great information. And I'm grateful that I'm not a part.
Thank you.
Yeah, I'm grateful that I'm not a part of the conflicts that you described. For my tenant is Section 8, so I'm getting paid.
Oh, good. You're one of the lucky ones.
Yeah, thank God. Yes. Thank you very much. Nice meeting you.
No problem. Thank you all.
Thank you very much. Very
Have a
informative.
good day,
Thank you.
everybody. Tomorrow's
Sure.
the listing
Bye-bye.
paperwork. Make sure y'all come back tomorrow, Wednesday, 2 p.m. listing paperwork, and I'll have an insurance guy, Raj Bensel from A to Z Home Inspections.
Oh, okay, great. Thank
Yeah,
you.
listing paperwork, Raj. So see y'all tomorrow, 2 p.m.
Bye-bye.
Bye.
Thank you.
Bye, everyone.
Bye-bye.
Thank you.
Bye-bye.
Bye. Thank you.
Bye-bye.